your dime at this point. Hi, we're going to start and let people wander in. I'm Barbara Hurst. I'm the director of the Pro Se Programs program at the U.S. District Court here. And this CLE series, as the one last year, is brought to you under the sponsorship of the Pro Se Programs program. Because one of our not so subtle messages is that we want you to be aware of the court's pro bono program, through which volunteer attorneys volunteer to represent otherwise pro se litigants in litigation here in the federal court. There's information about it on the website. We're not going to suffocate you with information about it over the next 3 months or until April 7th, which is our last session. We will be talking a little bit more about it on April 7th, and we may just remind you about it at every session. And it's a program that emphasizes mentors and mentees. So if you are new to civil rights litigation and want to get in the game, it is a good way of doing so because we can match you with an attorney who's been in it for a long time. Welcome to the first session of the 2026 series. We have Sonia Dio, who is moderating the panel, who's over on my far right. Sonia is a sole practitioner who specializes in employment law, but does also a vast array of civil rights work. Carly Iafredi, next to her, is a labor and employment lawyer, as well as an adjunct professor at Roger Williams Law School. Lauren Hill is the chief legal counsel at the Rhode Island Human Rights Commission, and she's going to particularly talk about housing, which is a specialty. And finally, Kate Bowden, who is a senior attorney, has been with the Rhode Island, with Disability Rights Rhode Island, that used to be Disability Law Center, with a lot of experience in general disability law. So thank you for coming. We adjourn at 5:10, which gives us 2 full CLE credits. They're general credits for this session. And you're going to be required to leave the building by the back door, which is, for those of you who haven't traversed the building yet, you simply take a left out of this door, go all the way down to the end, and another left brings you to another security machine and out to the back parking lot, where they may have to actually let you out with a key card. But there's a protest going on the front steps, starting at about 5:15 or 5:30. People are protesting the funding of ICE, particularly legislation that is pending in the Senate now. So even if you intend to join the protest, the CSOs are going to require you, or the marshals are going to require you to leave by the back door and walk around the building. Sorry for the inconvenience. And if there's anything, any questions you have or anything you need, you can find me after the program somewhere over there. Sonia. Good afternoon, everybody. We are running this session very much like we're going to present in different areas. Each of us is taking a topic. If you have any questions while we're presenting, please feel free to stop us. We intend to have more of a conversational format here. And you should have the format that gives you at least the piece of paper, rather, that has the format on it so that you can follow a little bit about where we intend to go today. With that, I think we're starting with you, right, Carly? Or you could sit there.
No, that's okay. I'm gonna stand. Okay. I'm a stander. Good afternoon, everyone. I've been assigned the task of addressing what I would say are 3 major statutes in the area of employment discrimination that I frequently litigate in those areas, which is Title VII, the ADEA, which is the Age Discrimination and Employment Act, and the Americans with Disabilities Act. I will sort of put a little program note here, which is this is a very basic outline of those statutes and what they cover. And so this is not going to do much for like the Mark Gagliardis or the Cynthia Hyatts of the room. It is more directed at those who maybe don't practice in these areas very frequently. And one thing that just an advertisement is that we really need people in Rhode Island to take on these types of cases. There are not enough of us doing this work, and we're getting older. Not me, but the other people that do this work. So I would just encourage you, if you're on the newer end of your law practice and you're at all interested in these areas, you can always call any of us, Sonia or Mark or myself. And I'm talking about from the plaintiff side, because we're all very generous with our time. And it's an important area. So that's my commercial introduction to this. So let's start with Title VII. I'm sure most of you have heard of Title VII, which is from the Civil Rights Act of 1964, of course. And the statutory citation is 42 U.S.C. 2000 with a little e, if you ever want to go look at what's actually in there. And the statute prohibits discriminatory employment practices based upon race, color, sex, sexual orientation, and transgender status, although I always put an asterisk there because those words are not in the statute. That's just a judicial interpretation that we don't know how long we'll be able to hold on to. National origin and religion. And so generally, it's an unlawful employment practice for an employer to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any person with respect to any of their conditions of employment on the basis of that protected category. Okay, so that's the pretty simple explanation of what Title VII prohibits. In terms of who's covered by Title VII, it's employers with 15 or more employees. And that's something important to consider, because if you are dealing with a small employer, they're not going to be covered by Title VII, and you're not going to be able to sue them in federal court for the most part. And so you would have to turn to our state law counterparts if you were in that situation, because our state law counterpart, the Fair Employment Practices Act, covers employers with 4 or more employees. So that's just kind of a basic, knowing who is covered. With respect to who is an employee, that's also something that you have to be thinking about whether you actually have an employee. And certainly, most people are going to be employees of their employers, but you just have to think about whether you might have someone who's a volunteer or an independent contractor or someone who's undocumented.
Hey, Carly,
So, yep.
what about RCRA? Does it have a restriction on the number of employees that an employer must employ?
It does not. So there's another state law that we frequently use. Thank you for that. The Rhode Island Civil Rights Act. It's 42-112-1. Again, this is going to maybe sound confusing, but I hope not. That's patterned after a federal statute, Section 1981, and it's much broader than an employment statute. It covers discrimination outside of employment, but also in employment. And that's another good backup in the event you have sort of an odd situation that doesn't quite fit under Title VII or under the Fair Employment Practices Act. And the other fun thing, which I was about to address, statute of limitations, is that the Rhode Island Civil Rights Act has a 3-year statute of limitations. So in the event you got into some trouble with your timing, that's always a nice backup. So back to who's an employee for purposes of Title VII. The other thing you have to think about is there are exceptions for religious employers. And I mentioned a moment ago volunteers and independent contractors. There are cases that say that volunteers and independent contractors are not covered. This is not a complicated presentation, so I won't get into maybe some ideas there, but these are things to just think about. With respect to the undocumented worker, what used to be the policy of the EEOC was that they would not look into an employee's status when it came to whether they would entertain a discrimination complaint at the EEOC level. I think that's still what's on their website. I have no idea, given the administration right now, whether that's anything you would want to play with. I would stay at the state level if I was in a situation where I had an undocumented worker as an employee in an employment discrimination case. I, in fact, had one within the last 5 years. It's just something that the Rhode Island Commission for Human Rights, there's no mechanism by which they're asking that question. They're just adjudicating whether there's a violation of the law. So on the issue of something else that you need to know about litigating in this area, one of the very critical things that you need to know is that these statutes require you to exhaust your administrative remedies. You cannot just walk into court and file a Title VII claim against your former employer. You must, in fact, first file a charge of discrimination with either your state agency, which is the Rhode Island Commission for Human Rights, or with the EEOC. If you file here in Rhode Island, what used to happen is that your charge would be co-filed with the EEOC, and then you would end up being able to get what's called the right to sue, which I'll get to in a minute, from both agencies. And you'd be able to make a choice as to whether you would then sue in state court or sue in federal court. But the important thing to be thinking about is no matter what, you can't file a case alleging a violation of Title VII without first exhausting your administrative remedies. When you must file a charge, how much time do you have? So getting to that statute of limitations question. With charges of discrimination, you need to file your charge within either 180 days of, I'm just going to say for purposes of this presentation, the last act of discrimination, or 300 days. And whether it's 180 or 300 is, and this is EEOC that we're talking about right now, is dependent upon whether there's a local agency that also handles discrimination charges. So because we're in Rhode Island, it's 300 days. So you only have 300 days to file a charge with the EEOC. If you're talking about filing a charge at the commission, you have a little bit longer, you have a year. Okay, so just basics. I think I might have a Title VII complaint or a Fair Employment Practices complaint, race discrimination, sex discrimination, religious discrimination. I have to have in the back of my mind that I probably want to get that charge filed within 300 days, so I have the option of both rights to sue.
Right, Carly, and the 365 with respect to the commission is only for state law claims, right?
That's correct.
Title VII still needs to be within 300.
Yes. So these are important. And for people who do constitutional law claims or personal injury, you know, we're talking about a much shorter period of time that we're working with here, unless you mess up and you're left with the Rhode Island Civil Rights Act claim. If you file one count under the Rhode Island Civil Rights Act in state court, most likely they're going to look at you, not they, but your opponent is going to say, yeah, you missed the 1 year or the 300 days. Not that I've ever been in that situation. So just as a reminder, go ahead, yes.
Rudimentary question. If you're filing a charge with the Rhode Island Commission for Human Rights, let's say you get a determination of probable cause and a right to sue letter, that allows you to sue in state court, but it wouldn't allow you to sue in federal court?
Unless it was co-filed, oh, sorry.
But you'd have to get an EEOC determination as well.
Right, exactly, yep.
Can I pipe in on that
Go ahead.
quickly? So generally when a case is co-filed and you request a right to sue from the commission, EEOC adopts the commission's probable cause and also issues the right to sue. Is that correct? I'm looking at Cynthia because she's
Yep.
been the longtime legal counsel at the commission and is now one of our commissioners.
Well, you know what I was thinking too? I was thinking in my head that somehow we used to have to check the box on the form if we wanted it co-filed.
Yep.
And I'm guessing that because I use a pre-filled form now in my computer, that it's automatically, the box is always checked. But is that still the rule, that the box has to be checked on your form?
I don't think it's a separate state and federal anymore. If you request the right to sue, you get the right to sue.
In both, yeah.
Yeah, no,
Right.
that's not exactly true. So what's happening right now, technically, well, not technically, this happened to me earlier today. I got a right to sue from the commission because I made a request for it by email. I don't have to fill out a form anymore. I got sent the right to sue from the commission almost immediately. I received a right to sue from the feds, I don't know, about 4.5 months later.
Ah, okay.
So
I
it's
think her issue
crazy.
was, is it automatically co-filed in the EEOC? I think it is because they have a work sharing agreement, irrespective of.
Yes, and Michael came to my class this year and explained the potential problems with the work share agreement under this administration, which is one of the reasons why you should make sure that you are filing in both places and that you get both of your rights to sue if you can. I have also had the situation that Sonia just mentioned, which is the right to sue from the commission came right away, and the right to sue from the feds came a long time after. And one of the things you should know about the right to sue is that it essentially says you have 90 days to file your lawsuit. It's almost like a new statute of limitations. You got the first one, you got your charge filed on time, but now you got a new one. And so if you don't have your federal right to sue yet, you certainly don't want to wait to get it before you exercise your right under the state court right to sue that you have. Was there another question? No, okay.
I did want to add, I had a weird thing happen not terribly long ago where I had the EEOC decline to investigate, but then the commission took over and investigated. I've had it happen a couple of times with this administration, actually.
Okay.
The EEOC investigates first. Sometimes they close the case very quickly and issue a notice of right to sue. The commission then reviews it, but we often reinvestigate cases that they've dismissed early.
There's a couple of people, as we mentioned, that are like real authorities, and Cynthia's one of them, and she's helpful. And so again, if this is something that you're interested in, everyone at the commission is really helpful. You can call and ask any questions, and they will answer them for you and point you in the right direction. And virtually everyone over there has been there a really long time. Other laws you might want to consider, so Title VII, and we're talking about these categories of discrimination, and we're talking about your state law counterparts, which are the Fair Employment Practice Act and the Rhode Island Civil Rights Act. I mentioned Section 1981. That's just about race discrimination. It's also a federal statute. There's no exhaustion requirement there. The statute of limitations, best of my recollection, is something like 4 years. One downside is there's no disparate impact claim. I'll talk in a minute about possible claims. And I don't believe there's any limits on damages. There's no caps on maximum amount of damages that you can recover under Section 1981. So just that's out there. So causes of action under Title VII and the counterparts generally can be described as you can have a cause of action for disparate treatment, disparate impact, harassment, or retaliation. All of those causes of action have different elements, and I'm not going to get into all of them because it would take a really long time. But a couple of things that you should just know in general. All of those causes of action, except disparate impact, require the plaintiffs to prove motive. Okay, this is intentional discrimination that we're talking about. And so it's not easy. These are hard cases to litigate. They're time consuming, and they require real proof. And so when you're considering taking these cases, in fact, Mark was just talking about examples of cases that he's no longer interested in. When you're taking these cases, you have to really believe that what you're dealing with is intentional discrimination, not just a possibility, but I think a belief that that's really what went on here. So just think about that. These are motive-based cases. You can prove your case by use of either direct or indirect evidence or both. And there's this thing that you might have heard about before in this area, and it's called the McDonnell-Douglas burden shifting framework. I personally hate it, but I'm just going to tell you what it's about, because unfortunately I'm not the one that decides whether this is something I have to deal with or not. It was designed as essentially a method of proof to be used at trial, because when you think about discrimination cases, very often no one's going to admit that the reason why they fired your client is because of race or sex or something like that. So you have to figure out, how am I going to develop evidence that would allow the fact finder to infer that discrimination was at work here? And a long time ago in the 70s, the Supreme Court decided that this McDonnell-Douglas case, we were going to develop this burden-shifting framework, and it's off to the races now, and we're stuck with it. And it's just something that you need to make sure that you're familiar with, because most often that is how your case is going to be measured in terms of success. If you can meet your burden under the McDonnell-Douglas burden-shifting framework, then you're going to succeed on summary judgment and maybe at trial. Sonia, or somebody, I think it was Sonia, printed out an outline for today, and it does have on the back what she calls, and I like this, very general standards for employment claims. Because, as I mentioned, this is a very hotly contested area of the law, and we can really go to town on any one of these elements on any given day. There are so many cases and so many different factual differences between them. So this is a very broad overview of what you're looking at when you are a plaintiff and you're thinking about, well, what do I have to know about my client's situation to be able to evaluate whether I have a good claim or not? And this is a good starting point. So another thing that's on my list of things to tell you about handling cases in this area is that under Title VII, you can proceed on what's called a sole motive, meaning you're trying to prove that the only reason this happened is because of your client's fill in the blank, okay? That was the sole reason. Gender was the only reason your client didn't get this promotion. But you can also proceed on what's called a mixed motive claim. If there's evidence of more than one motive, where there's one legitimate motive and one illegitimate motive, you can also proceed that way. And the language is now in the statute itself, and there's 9 million cases that will tell you what mixed motive is about. Mixed motive, excuse me. With respect to sexual harassment, you should just know that there are entirely different elements of a sexual harassment claim. We have things called a quid pro quo, a this for that, sort of if you do this, I will do this or not do that at work. That's different than a hostile work environment, which is usually a series of offensive things that happen over the course of time and cumulatively lead to a hostile work environment. There are affirmative defenses that are available in hostile work environment claims, and they're dependent upon essentially who perpetrates the harassment. So again, if you're thinking about proceeding and filing a harassment claim, it's not just, I had a jerky boss at work and he treated me badly. It has to be because of your status in that protected category. It has to be severe or pervasive. You have to believe it's offensive. It has to be offensive to an objective person. It has to be unwelcome. There's a lot of things that have to come to play in order for you to have a successful sexual harassment claim or another harassment claim based on any other protected status. Couple of fairly new things to consider with Title VII claims. We had a Supreme Court case last year called Ames versus Ohio. It's 2025. And it basically said that if you're filing a Title VII claim on behalf of what would traditionally be considered a majority group, such as a white person, there's no heightened burden. You would prove that claim the same way that you would prove any other claim, interestingly enough. We also had another case just in the last couple of years, Muldrow versus City of St. Louis, expanded essentially what is an adverse job action. So when you're filing, like, for example, a disparate treatment claim, you're saying, I was terminated because I'm a woman. You have to prove there's an adverse job action. In that scenario, it's your termination. That's an easy one. But in the past, there was a big debate about what about things that are less severe than that? Is that an adverse job action? And essentially what Muldrow did is lower the standard a bit so that there are a lot of things now that we can debate will be adverse job actions that used to not be adverse job actions. So go
What's
ahead.
happened in state court with that, do you know?
Nothing that I know of. In state court, did you say?
Yes.
No, I don't know, nothing. Our state court doesn't frequently decide employment discrimination cases. We don't often get any really new and exciting decisions out of the Rhode Island Supreme Court. I don't know what other people think about why that is, but I think I know, at least from my perspective, most of our cases get resolved at the trial court level and just don't have a reason for an appeal. I think in this area, if you do a good job and you really work up your cases in discovery, most often Chris Dawson is going to want to settle the case. I'm sorry, you're my only employer pick in the group right now. That's just what will happen. And if it does go to trial, you know, you have to think about what the cost of the appeal would be and what the motivation would be. I just don't think there's that many cases that go up there. Does anyone think differently?
I can say that I had one, I was representing an employer that could not, we wanted to appeal it, but the bond was prohibitive. Couldn't do it. Which, you know, can also come into that whole economic thing, because if I am an insurance company and I am representing an employer, it may be cheaper for me to settle the case. If I'm an individual employer without insurance, it gets even, just the cost of doing it was impossible.
Yep. Another just program note for new things in the last few years, the Pregnant Workers Fairness Act. This is 2023, and it's a law that now requires employers to provide accommodations for pregnant workers similar to the ADA. We have that in the Fair Employment Practices Act in 28-5.7.4, but that was newer on the federal level. And I'm just checking to see if there was anything else I wanted to tell you about Title VII before I do have another page, stand by. Religious accommodation, Groff v. DeJoy, also a 2023 decision. The employer may have a burden to accommodate religion in the workplace, and if they don't, that could be a violation of Title VII. The accommodation obligation is so long as it does not cause an undue hardship. That's not the new part. The new part is before Groff, for an employer to show undue hardship, essentially they were only required to show that the impact was more than de minimis on the business, and then they'd be able to say we're not accommodating. Now the court has made it a little bit more difficult to avoid religious accommodation. An employer can establish undue hardship only if there's evidence that the accommodation would result in substantial increased cost to the business. Another issue that comes up under Title VII is or has been, it's kind of been a hot topic, is hairstyle-based discrimination. You might have heard of the Crown Act on the federal level. Just recently, our state law, we added under the Fair Employment Practices Act language that essentially includes discrimination based on protective hairstyles, so you should know about that. And then we've also added, in connection with the pregnancy-related accommodation language, that employers must also accommodate menopause-related conditions, which I think we might be one of the first or the first state in the country to have that.
We are the very first.
Yeah, which is pretty neat. So that's Title VII in a nutshell. There's much more, obviously, but that's where you want to go if you think you might have a discrimination claim that's based on race or sex or national origin or color, religion. I said national origin. So that's your starting point. Age discrimination is not part of Title VII. It's addressed in a totally different statute, the Age Discrimination and Employment Act. That was enacted just shortly after in 1967. You still have to exhaust your administrative remedies, and so you still would have to go to the EEOC if you were trying to pursue an ADEA claim. Here in Rhode Island, age discrimination is covered by the Fair Employment Practices Act. So if you just think of the difference there, if you're on the federal level, you're dealing with two different statutes. If you're on the state level, you're within one statute. You're still in the FEPA. The ADEA covers employers with 20 or more employees. And obviously, same thing's going to dictate if you have a smaller employer and you want to claim age discrimination, you're going to need to go to your state statute. And obviously, age discrimination involves prohibition on treating an applicant or an employee less favorable because of his or her age. And the ADEA only prohibits discrimination against people who are at least age 40. Okay, so that's the number one thing, is in order to have an age discrimination complaint, you need to at least be 40 years old. You can still have a discrimination claim if both the victim of discrimination and the person perpetrating the discrimination are over 40. That's important to think about. It's the same claims: disparate treatment, disparate impact, harassment claim, retaliation. One of the things you should think about is the difference in age between essentially the person who's claiming discrimination and the person who may have replaced that person, or the person who got the promotion instead of the person who's claiming age discrimination. And generally, there's this terminology that you have to say that you were treated differently than someone who's substantially younger. 3 to 5 years isn't going to do it around here. You know, I like to try to think of it as like at least 10 years. There's no like specific rule about it, but it's just generally not going to be believable if you're saying, hey, my person is, 45 and the person who replaced them was 41, and so therefore we've been the victim of age discrimination. So that's one of the things you should think about. And you should also think about the age of the decision maker, although that also is not a dispositive thing, but it's just something to keep in mind. If you have, the person who's making the decision is 75 and the person who they're letting go is 70, that might not be what you're looking at in terms of a good case. And I do think age discrimination is one of those things where you really want to have some indicator that that's really what's happening. You can't just have I'm over 40 and I got fired, so I have an age discrimination case. You still have to prove causation. Still following McDonnell Douglas, as I mentioned, if you want some kind of a guideline. And there is a difference in remedies, which I'll discuss in a minute. The Americans with Disabilities Act is that third statute I wanted to mention in terms of big federal laws. We could do probably 2 classes on the ADA. So this is a real brief description, but I want to make sure everybody understands that these are options. Americans with Disabilities Act, 1990, you still got to exhaust your administrative remedies. There were significant amendments to the statute in 2008, and so when you're researching in this area, not that you'd want to rely on old cases, but it's something to just keep in mind. If I see something that's pre-2008, I have to really not consider it because so much changed after that. It is unlawful for an employer to discriminate against an individual on the basis of disability in regards to job application procedures, hiring, advancement. You can't discharge an employee for disability. It covers compensation, job training, all conditions and privileges of employment. One of the things that's different about the ADA is that there's an affirmative obligation to accommodate a person with disability. So sometimes in the area of discrimination, we're thinking about, we want to make sure that an employer is treating everyone the same, gender, race, that sort of thing, religion. But with disability, it's a little bit different. This is sort of, or it is, requiring the employee to possibly treat someone with a disability better. I hate to use that word, but in order to make sure that that person can operate equally in the workplace. And so sometimes, especially, I represent a lot of labor unions, and, you know, union members are like, how come that person is getting this thing? That's not fair. And I'm like, no, that's actually exactly what the statute requires the employer to do so that that employee can operate in the workplace on the same playing field that you are operating on without your disability. The accommodation part of the ADA, employers only required to provide a reasonable accommodation, and the employer can avoid providing the accommodation if they demonstrate an undue hardship, which has a different definition than the one I just spoke about when it comes to religious accommodation. One of the great things about the ADA is there are very extensive regulations. This is a very technical area. Every word in the statute has its own very detailed and technical definition and meaning. And so when you say, okay, this person has a disability, just figuring out if they have a disability is an exercise. Just figuring out if the person can perform the essential functions of the job with or without accommodation, whether the person is a qualified individual with a disability. All of those things are necessary elements of your claim, and all of them have very specific meaning. It might sound difficult, and sometimes it is, but I find it, because the regulations are there, the answers are really pretty good. You know what you got right up front, I think. So in order to practice in this area, you really need to know those regulations. Same causes of action plus, so you have your disparate treatment and your disparate impact and your harassment or retaliation, but you also have a failure to accommodate and what I call a failure to engage in the interactive process. One of the other things that's different about the ADA is that an employer has an obligation to engage in an interactive process with the employee seeking the accommodation. And that's designed so that we're not going past each other. And it's one of those things that the employee might say, here's what I really need. And the employer might say, we cannot do that. But the statute imposes the obligation to continue that dialogue, not to just say, okay, one effort is enough. The interactive process contemplates a further discussion.
But that's both sides, right? That's the employee and the employer.
That's correct. One of the other things you should consider when we're talking about disability discrimination is there's also Section 504 of the Rehabilitation Act of 1973. That applies to employers, either federal employers or employers who receive federal funds. Not my area of expertise, but just know about it. It exists. And then obviously you have your state law counterparts that are going along with your ADA. And in Rhode Island, we have not just the statutes I've mentioned before, but we also have the Rhode Island Civil Rights of People with Disabilities Act, which is 42-87-1. And so that's something to consider. Just briefly on remedies, Title VII makes available back pay, front pay, reinstatement, compensatory damages, punitive damages. You can get attorney's fees under all these civil rights statutes, and that's part of what makes it attractive for lawyers to take these cases, is because we know that ultimately there's an entitlement to attorney's fees, and that's important, right? Because these are important civil rights statutes, and we want to make sure that people who don't have the ability to pay lawyers have the ability to enforce these rights.
Barbara?
Go ahead.
And you should know that if you take a pro bono appointment, it only precludes you taking fees from the represented person, from the client. You can get still fees if you've got a case under any of these statutes that allow them and the court orders them against the other party or in settlement. That's a little more complicated. We're gonna have 2 sessions on attorney's fees. I think it's sessions 4 and 5, maybe a little bit later in the winter.
Great. Under Title VII, there are caps on damages based on the size of the employer. So just remember that and be aware of it. Under the ADEA, so the Age Discrimination Act, you're not going to get compensatory damages and you're not going to get punitive damages, but instead the statute provides for liquidated damages, which is essentially double your back pay, but only if the plaintiff proves a willful violation. And there's still attorney's fees under the Age Discrimination Employment Act. That's another reason why you always want to include your state law claims, because we don't have those restrictions, at least off the top of my head, I don't think we do. At least that's how I've been proceeding all this time, is that sky's the limit under Rhode Island law.
And if it's brought here in federal court where you have your federal remedies and your state remedies, can you have your damages capped because of the federal caps, despite the fact you have a state claim pending here?
That's a question for someone else. Mark?
I'm sorry, can you repeat?
Come on, pay attention.
Short answer. I bring a claim here with a state and a federal cause of action. I succeed on both claims. I get a judgment for $1 million, which is above the cap. Can I get that awarded to me from the federal court, or am I stuck with that federal cap despite the fact I brought a straight
I wouldn't think so.
state claim?
No. Federal court has supplemental.
Right, so they've got to,
State claim.
yeah.
And the judge is probably gonna, well, I guess the jury instructions, the law is probably gonna be the same for both claims. So, no.
So just so the recording picked that up, Mark says no.
Okay. In other words, make sure you're pleading both your federal and state claim in federal court.
There are some jurisdictions where there are caps on damages. I know lawyers that have gotten crazy verdicts, $100 million that got reduced to $300,000. And those states don't have, they all have caps. They either don't have state discrimination laws or they only have the federal. The Congress needs to change that.
Yeah, another good reason to stay here.
There's a gentleman in the back who raised his hand.
Yeah, I'm just wondering, the topic of kind of the particular perils that undocumented workers might face through this process was brought up earlier. I talked to a lot of undocumented workers in my line of work, and I know that the question of remedies can also be somewhat complicated by their status, especially when it comes to things like reinstatement or back pay. How do you see somebody's legal status in the United States kind of playing into the remedies that you're discussing here under Title VII and ADEA?
Just to repeat that question
Yeah.
for the recording here, the gentleman is asking how it is that being in a status where you're undocumented or without proper work documentation might affect the remedies you might get from one of these claims.
I think the answer is, and I don't know if someone here has more experience with this, but the case law comes from Hoffman is the name of the case, which was an NLRB case, which I'm sure you're familiar with. And so in that case, for everyone else, there were undocumented workers who were, I think, terminated based on protected conduct under the National Labor Relations Act. And then there was a decision which I think reinstated them and awarded them back pay. And then there was an issue with there would be no way to award these workers back pay without otherwise violating federal law because they were not supposed to be working, I guess. They were illegal. So in employment discrimination, I can tell you the textbook says, when I teach the kids, that the EEOC has basically said, we're still going to enforce the law, and I don't remember whether the EEOC says anything about the limitation on remedies, but my guess is they would follow that. But I don't know, Cynthia. I really don't.
Not sure either.
Yeah,
In a few cases that said that the damages can't be given.
right, right. So if you are in that situation, it makes it very difficult to encourage someone there to pursue that type of claim if they're not ultimately going to get damages. That case that I mentioned that I have, which was a termination case, and the plaintiff was or is undocumented, went to hearing at the commission, but she lost. And so we never got to the issue of damages. We appealed to the Superior Court, and the Superior Court remanded it back to the commission, not on this issue, on the merits. The commission reissued its decision saying, I lose. I took the appeal back to the Superior Court, and that's where it is. If someday I win for this person, then I'd be facing that issue. But at this point, I'm just not giving up until it's over, no matter what happens. So I'm in it for the long haul. Go ahead.
Damages should be available for pain and suffering.
Right. It might be the wages. Right. It might be the wages that's the issue.
Yeah, from my perspective, my way of playing this right now would be to file a discrimination claim with the commission, hope that the commission takes its sweet time, maybe up to 2 years, to make a decision or decide that they're not going to make a decision. And then just before that 2-year mark, put it in state court, and then pray that we have a change of administration. That is how I am handling these at the moment.
For your reference, it takes about 300 days on average for a case to work its way, for a charge to work its way through the commission. So I don't know if that helps or hurts.
Oh, yeah, no, you wait almost to your year, and then you bank on the 300 days, and you go, well, I'm already a year in, so where am I looking at as far as coming out, hopefully I have a new administration? That's my plan. Oh, and also, we have a group that's working on trying to get virtual court hearings, so really unlikely you wouldn't end up in the next administration, depending upon who they are anyway.
Aren't you concerned that the employer is gonna call ICE and get them deported? I mean, is it really worth it to risk that? I don't know, that'd be my concern.
I'm not necessarily worried about that on a commission charge. And if you want to talk about how to get around that, I can talk to you about that. But I'm not worried about it.
Yeah, this is like one of those things that, at least for me, that's the one person in 25 years that's ever been undocumented that I've represented. So I can't tell you why. It's just who calls, right?
Yep.
And how people find you. So it's definitely not a situation that's going to come up very often, and probably really the chances have gone way down right now. So anyway, there's one more law I want to just tell you something quick about, and then I have to stop here. There is a federal law called the Genetic Information Discrimination Act that you should know about. Genetic information discrimination occurs when individuals are treated unfairly based on their genetic information. And this comes up in employment and also in health insurance contexts. It applies to employers with 15 or more employees. It also requires administrative exhaustion. It is also covered in state law. 28-6.7-1 provides that genetic testing cannot be a condition of employment. And I'm only bringing it up because I was asked to mention it. I have never had anyone call me claiming that they've been discriminated on the basis of their genetic information, but it's a thing. There are a number of other employment statutes that I didn't mention here today. Like I said at the beginning, if it's something you're interested in doing, you should definitely reach out to any one of us. It's not the easiest area of law to practice in, but I think it is rewarding. I'm going to turn it over to someone at this point.
I thought, Lauren, you were going to talk a little bit about public accommodations.
Oh, am I?
Oh, I don't know. Or am I confused?
I mean, I can say a little bit about public accommodations. I'm going to kind of preface this by saying, so the Commission for Human Rights investigates and enforces the state's anti-discrimination laws. We also investigate federal discrimination laws, but as to whether we have any enforcement authority over those, I think the answer to that is not exactly. Often what happens is when we come to a decision to say that the charge has probable cause and there's enough in the charge to move forward to a hearing or to a court case, often our federal partners will adopt our determination on that. One thing is that we don't have a partnership on public accommodations with any federal agency. So we're limited to the state's public accommodation laws. So I think that's 1115 Rhode Island general laws. Is that correct?
That may be correct.
Okay. And if you've 1124, if you've ever read that, it's a really interesting and outdated, and it has one of those, including but not limited to. And so it includes things like ice cream parlors and aerodromes. And if you know what that is, I don't. But it doesn't say some things like just restaurants. Now, most of those things we would, case law or practice would lead us to include those as being as a public accommodation under the state law. But because of how oddly it's drafted, we end up with some interesting cases on that basis. But we don't have any authority to enforce the ADA, which is sort of the federal public accommodations law. And that covers, one of the big things that covers is an access of service animals to public spaces. Now, if you're thinking, oh no, animals. So there's a difference between, say, a service animal and what people call emotional support animals or assistance animals. Service animals are really specifically a dog or a miniature horse, although I've never seen one. I've never seen a service animal that's miniature horse. I've seen a miniature horse, just to be clear. And that has to be trained to do a specific thing for the owner who has a disability. So your classic example is, of course, you're seeing eye dog for a person who's blind or who has a vision impairment. You will also see seizure alert dogs. Or diabetic alert dogs that can actually smell when people's blood sugar is low. That's an animal that has been trained for a really specific purpose that helps mitigate that person's disability. Animals, those service animals, are allowed in a lot of public places. Your emotional support animals, they're not trained for anything in specific. They're just to provide emotional support. To help mitigate the symptoms of someone's disability. The ADA does not guarantee access for what we would call assistance animals that are emotional support animals into those public spaces. So if someone is trying to take their, peacock into the restaurant because it's their emotional support peacock, the restaurant can say no. Now, this looks a little different in housing. So in housing, you live in your house, right? So your right to have an animal, your emotional support animal, is also a little different from being in a public space. One thing I will say about service animals, sorry, just to backtrack a little bit. One thing about service animals in public spaces is that the dog still has to be under the owner's control. So if you have a purported service animal coming into a public space and it is making a ruckus or it's not under the owner's control, you can still ask them to leave. If the dog bites somebody, just because somebody says, oh, it's my service animal, if it's posing a danger to the people around. Yes.
And to bring a service animal into a motel or a hotel, you have to stay, the service animal has to be with its owner the entire time, as I understand it. So they can't leave the service animal in the room and go out to dinner. Is that right?
Honestly, I don't know. That probably sounds like a good idea.
I have a brother who used to run a motel, and we looked it up.
Yeah.
Are you done?
Yes.
I just wanted to add something to that. I just wanted to add something to that, one case that I had that I see happening a lot is when you have like a apartment complex or condominium complex that has a no pet policy or a restricted breed policy. And the cases are very clear that the apartment complex has to make a reasonable accommodation to that policy and allow you to have the animal. And where it becomes tricky is we have a restricted breed policy. You can't have pit bulls, Rottweilers, German Shepherds, and the emotional support animal is, guess what, a pit bull. And the courts say, the HUD has a regulation that says you have to jump through all these hoops before you say no. So it's very controversial. A lot of the the folks that run the apartment complexes don't know about the law, and they just say no, it's on our restricted breed list, and they get into a lot of trouble because of it.
That's very true. I will also say that something we hear a lot from apartment complex or other housing providers is that the reason they have a restricted breed policy is because of their insurance coverage. And then if they were to permit an animal that's on the restricted breed category into their complex or their housing, that it would either terminate their contract, their insurance, or it would substantially increase their rates. I'm not aware of any case law that addresses that. I will say that the Federal Fair Housing Act says that it shall be prohibited to, and then there's a whole list of things, and failing to make a reasonable accommodation is one of those. So if the reason that you have to reject a tenant is because your housing, your insurance provider is saying, well, we'll lose our insurance if we permit this animal, is the insurance provider then responsible for a violation of the Fair Housing Act? Again, I haven't seen a case like that, but it's something worth thinking about.
I have a question.
Sure.
Since that leads you back to a reasonable accommodation analysis, it's the wrong breed, wouldn't the proportion of the increased cost for the insurance be a relevant factor for the reasonable accommodation analysis?
As far as the undue burden to the complex, yes. So there's two ways that there are basically two defenses for a reasonable accommodation, to deny a reasonable accommodation request. One is the undue burden. That is to say, it's going to be really expensive. It's going to change something fundamental about the housing. One good example that I can think of is we got a charge from someone who asked their landlord to install an elevator in their apartment unit. That is both very expensive, but also it might change it might impact the structural integrity of the building. It, has some interesting knock-on effects there. But for an animal in particular, one of the other defenses is dangerousness, that the animal is dangerous to other people who live in the complex. And that's an individual determination that's based on the animal itself. So you can't just say, oh, well, on average, poodles bite more people. Poodles don't bite more people. Please don't come for me. And so we don't allow poodles. It has to be that particular poodle is a biter and it has a history of being a biter, or it's otherwise a danger. So what Jen was just asking about is the undue burden. So it is relevant how much someone's insurance would increase, or whether they would have their insurance just completely yanked by the provider if they were to permit an animal on the restricted breed.
And my understanding is that they can't pass down the insurance increase to the tenant, the disabled person.
Yeah, that's part of it, is that one of the things, so often what we'll see is that an apartment complex will in fact permit someone to have their assistance animal, but they'll charge them. They'll have a pet fee or a registration fee, or like Mark said, roll down the insurance increase to the tenant. That in itself is a violation of the reasonable accommodation policy, asking your tenant to pay more for their reasonable accommodation. Now, I will say that that's not a service animal or an assistance animal isn't the only accommodation. A lot of times it's things like, I need to have a parking space closer to my front door because I'm disabled, or a lot of people need a first floor apartment so that they don't have to climb stairs. Those are also reasonable accommodations that people ask for that tend to be a lot less controversial and dramatic. Any other questions, thoughts on animals before I move on to something else? Okay. So just to kind of loop back to the beginning of the Fair Housing Act. So you have the who and you have the what, right? The who does it protect? And those categories, those protected categories, are mostly the same that you find in employment. It's race, color, national origin, religion, sex, familial status, disability. Familial status is a little different because, we have seen landlords who say, we don't take children. That's discrimination on the basis of familial status. Now, that's the Federal Fair Housing Act. The Fair Housing Practices Act, that's Rhode Island's state version of that, has additional protected categories. Those include marital status, military status, lawful source of income, housing status, which is whether someone has previously been unhoused, and if someone has been the victim of domestic abuse. We have actually seen an uptick in military status cases recently, with some apartment complexes requesting an active duty military member's orders to substantiate that they will be in the location for the duration of the lease, and then refusing to lease to them when their orders didn't show they would be there for a year. Now, we got them to change that policy because it's pretty transparently only for people who are active duty military. But we've seen other similar things. I have heard anecdotally that it can be difficult to buy a house with a Veterans Association loan, a VA loan. As to whether that's discrimination on the basis of someone's military status is yet to be seen. But we are seeing a lot more of those rental issues with people who may or may not be in Rhode Island for the duration of their lease because of their military orders. Lawful source of income is probably the other one that we see a lot out of the just state categories. Lawful source of income is like your Section 8 housing voucher, or a rental relief program or something like that. That it's not specifically income like earned income, but it is funds that will help you pay for your housing accommodation.
Is a landlord required to accept Section 8?
So yes, a landlord is required to accept Section 8. I'll say that with an asterisk, that financially it has to still work out that the Section 8 will cover enough of the tenant's payment and all of that. And the other part of that is that the statute obligates the landlord to do all of the things they need to do in order to accept Section 8. So if they have to fill out paperwork or if they have to have an inspection, that's also part of that, the Fair Housing Practices Act. We've seen a number of cases on that. There's not a lot of case law because there's not a lot of other jurisdictions where that's a protected category. But that's, oh, yes.
If the landlord's property is not up to habitable standards, and in order to accept a Section 8 tenant, the landlord would have to spend money to improve the property. And if the landlord refuses to spend money to improve the property, is that a violation?
So that specific issue hasn't come up yet. My understanding is that if the landlord were to get the inspection and failed the inspection, that the landlord had complied with the requirements of the program and had been denied on the basis that it was not a habitable property. There hasn't been any, I haven't seen a case like that, but that's sort of my feeling on what would happen. Yes.
Is there case law on point that determines whether sex under the Fair Housing Act includes gender?
So one of the things, so I'm not aware of any specific cases. So Carly talked a little bit about this, the Bostock case. And that was an employment case that said that gender identity, sexual orientation were sort of part of sex. And we'd sort of been drifting on that, right? Like, well, if it's in employment, we often use the same cases in interpreting the fair housing statutes that we do interpreting the fair employment practices. That was really inelegantly stated, but
We got you.
okay. So, relying on the Bostock case, we had been saying, yes, that should be included. Now, HUD, who's our federal partner for our housing cases, recently sent us some guidance saying we're no longer going to accept cases based on gender identity for co-filing. Like, you can still do them, but we're not going to pay you for them. And while they haven't explicitly said sexual orientation is also something that they're not wanting to investigate, it's likely. The other part of that is, in order to be qualified to have a disagreement with HUD, we have to be substantially equivalent. That is to say that if you file a charge with the commission, you're going to get basically the same service you would have if you filed with HUD. That our laws are basically the same, our remedies are basically the same. And typically, you just had to cover the same things that the Fair Housing Act did as far as protected categories. And if you covered other things, great, but we're not going to pay you for them. So we received guidance recently saying that if your state covers additional protected categories, you're running the risk of being not certified as substantially equivalent anymore. We'd always taken that as the FHA is a floor, not a ceiling. And now they're saying, nope, it's a ceiling. They haven't taken any action on that yet, but it's really kind of a gray area as to whether they're going to continue enforcing cases that allege discrimination on the basis of gender identity, sexual orientation, and other things that we've previously included in discrimination based on sex.
Cynthia?
I just want to clarify the state fair housing law explicitly covers gender identity and sexual orientation.
Yes.
So you are covered under state law.
I did notice that, so I did notice there's an exception for dwellings under a certain number of units that are owner occupied.
So I know that there's an exception called colloquially known as the Mrs. Murphy exception for like this little old lady named Mrs. Murphy who is in an owner occupied house. And that's my understanding is that is an exception on familial status,
I thought it was sexual orientation.
but you may be correct. And essentially, if it's fewer than 4 units and owner occupied, then you have some limited exception. I will say, though, it doesn't protect you against discriminatory advertising, though. So if you put out an ad and said, "I have a unit to rent, but I'm not going to rent to gay people," then even if they wouldn't have been able, you would have been able to refuse them on the basis of the Mrs. Murphy exception, you could still be on the hook for the discriminatory advertising. And that's one of the differences, I think, between fair employment and fair housing, is that there are a lot more sort of prohibited acts, right? So you have excuse me, let me start that sentence over again. Refusing to rent or sell to somebody, refusing to deal with them. So no, we don't have your kind here. We're not even going to talk to you about what the rent is. Evicting someone on the basis of their protected category. Discriminatory terms and conditions. I recently heard an example of this where there was a condo association that said, "Yeah, we'll let families live here, but your minor children can't use any of the facilities ever." So that's like a discriminatory terms and conditions kind of claim. Some of the ones that you probably think of stereotypically are like steering. Oh, you might be more comfortable in this neighborhood where the people look like you. But we also have retaliation, which is a big one. So if you suffer some sort of and it's very much like the same analysis that you would have under employment, is that if you suffer some sort of adverse action because you have exercised your rights under the Fair Housing Act, then you have a claim based on just the retaliation. And you might have situations even where your underlying claim may not have probable cause, but your retaliation claim might go forward.
I was just going to ask you whether it's the same as an employment, which is you don't have to prove that the underlying discrimination complaint had merit. You just have to prove that you made the complaint.
And I think we would probably also say made in good faith.
Yeah.
That you honestly believed you had a claim and there's some basis to it. The fact that there was some technical reason why your underlying claim didn't survive and your retaliation claim did. If you were doing this for the purpose of, I guess, retaliating against your employer for retaliation, then that's probably not good. How are we doing on time? I don't want to.
I think that I need to pull some FLSA stuff here.
Okay.
All right.
Well, I will stop talking, but if you have other questions, I would be happy to address them. Sure.
Hi, thank you. That was loud, sorry. I did have a question, just like not just with housing, but also employment. Like when you have any of these like protected classes, like I've noticed a lot of respondents will like use a proxy to say, oh, we're not discriminating based on military status. We're discriminating based on the ability to stay for the entire lease, or we're not discriminating. The case this summer that the Supreme Court ruled on in Scrimetti, we're not discriminating based on gender or transgender status. We're discriminating based on medical care. So I suppose if you're representing a plaintiff in these cases and the respondent is like kind of using one of these proxies to say we're not targeting a protected class, is the way around that just to try to provide as much indirect evidence as you can to have the court come to a favorable conclusion?
Yeah, you do. I mean, at least in employment, you really do have to prove that the adverse job action was because of the protected category and not something that I think it's called, Cynthia, correct me, but a trait that's analytically distinct. So the common one is like, for example, somebody who's pension eligible, and so I'm discriminating against you because I want to deprive you of that pension benefit, that is not also age discrimination just because you happen to be older, right? So it has to be because of age.
I mean, you can have a mixed motive where, part of what is the employer citing to you is a totally legitimate business reason for their actions. But if it is partially motivated, and I think it would be indirect evidence and massing indirect evidence to prove up that while the employer is representing it's for a legitimate business reason, it is actually motivated by this person's protected category, as evidenced by nearness in time to when it happened, or things that had been said, things of that nature.
Cynthia?
There's also a possibility of I'm sorry. There's also a possibility of alleging disparate impact, which is that there is a neutral standard, but it screens out, for example, military members. But as Carly was saying, with pensions, for some reason, the U.S. Supreme Court threw out that theory, just for that
And it would
case.
be different if the fact pattern was, in order to be eligible for your pension, you had to reach a certain age, as opposed to, in that case, I think it was you needed 10 years of service to be vested, so you really could be much younger, right? But if you had a case where it was the same form of discrimination and the pension plan was, you had to be 65, well, then maybe it would be different. So it's not a definite no, but you really have to be able to connect those two things.
And EEOC and HUD have both said that they are deprioritizing enforcement of cases based on disparate impact. So that's something to be aware of if you're co-filing a case.
All right, I'm going to change subject and take us into wage and hour work here just for a little bit. Wage and hour work is kind of sort of how I ended up doing employment law, if that makes any sense. Basically, there are very few employers that I've looked at their pay system, unless they are a major corporation, where I haven't been able to find some sort of violation. And so as a plaintiff's lawyer, I look at wage and hour claims and I go that I think that these are the sorts of things that I want to look at many times in conjunction with some of these other discriminatory matters. And the reason for that is that if I'm bringing a claim under the Fair Labor Standards Act, which is the federal law that governs both overtime and minimum wage, I'm looking at a presumptive double damages on that claim plus attorney's fees and costs, provided I bring it within 2 years of the pay period in which the individual is not paid correctly, whether that's for overtime or for minimum wage. And in the state system, it's supposed to be 3 times the amount that the employee would have been entitled to be paid plus attorney's fees and cost. So from my perspective, wage and hour claims are both things that are provable most of the time on paper. They're things that are summary judgment cases on behalf of plaintiffs, which is very odd in the world of talking about a burden shifting analysis. Does not exist in the wage context, and generally profitable. So a couple of things about these claims to know, very briefly, is that we still have a federal minimum wage of $7.25, which means for somebody that is a non-tipped worker, they have to be paid that. We have a state minimum wage act of $16 an hour. Again, if you're a tipped worker, that can be different. But in either event, if an individual is a tipped worker, they have to be able to make up at least until that hourly amount, like on a per week basis, or they're entitled to make a claim for minimum wage violations. With respect to overtime, which is where these claims generally exist in my practice, what happens is I have a non-exempt worker, meaning somebody generally who's more blue collar, and they're not being paid for work they're doing either before a shift, while they're on a break, or for hours that they're working after they've left the place of employment. And you end up with a place where they're entitled to the wage again. And under the federal law, double that wage, and under the state law, up to 3 times that wage. Rhode Island kind of follows the federal government when it comes to what salary requirements are. Essentially, right now, to be a salaried worker who might be exempt from overtime, at present, you have to make $35,568 a year. Now, it's debatable. There's a case out of Texas that struck down higher amounts that would be payable to a worker before they could be exempt. But that is sort of the baseline as it stands right now as far as Department of Labor is concerned. And there's also this concept of what's known as a highly compensated employee, somebody who makes so much money that irrespective of what they're doing, even if they are the proverbial plumber, somebody who's a very blue-collar person, they're still going to be exempt from overtime. That standard right now is $107,000 plus a little bit. There's also certain types of workers that are completely exempt from overtime requirements, such as doctors, lawyers, teachers, and outside sales employees. I'm going to add that there's a little bit of debate on whether each of those people, simply because of their education, are exempt. You can have, for example, lawyers that are working as paralegals who are not exempt, and it would still be required to be paid on an hourly basis. Just so I say that bluntly, so everyone here hears that, your paralegals are required to be paid overtime, period. There's a case that came out a while back that says that all paralegals are not exempt from overtime. The other thing I want to point out is that we have some new record keeping and old record keeping requirements that apply to Rhode Island employers. Essentially, you are required as an employer, or all employers are required, to hold records for at least 3 years of the name, address, occupation, rate of pay, and amount paid each pay period, and hours worked each day and each week by its employees. And I do not know why Rhode Island law does this in particular, but that actually applies to exempt employees. So I myself, as the proprietor of my firm, am technically required under Rhode Island law to document my hours worked each day. Nobody's doing that, but that is the law. I'll also add that where that is helpful to an employer is when you've got somebody that you are paying and you've inappropriately classified them as salary exempt when they're not. It's very nice to have the actual hours that the person worked so that you can then figure out what the damages are, instead of ending up in litigation and paying lawyers to figure out what that number might be, or taking a flat guess on it. Because generally speaking, if I'm estimating the amount of hours that an employee is working, I'm going to estimate high. And if you have records that prove otherwise, you're going to want to have those. I do want to add very quickly, in Rhode Island law, we have sort of remnants of what I would call blue light laws. We have a Sunday pay statute, which means that there are a whole group of individuals that must be paid if they're required to work on Sundays. Exemptions are people who are in agriculture, maritime trades, people who are traditionally salary exempt, meaning doctors, lawyers, priests. But there's a lot of people who don't necessarily fall into that class. So it's one of those things that if you're going to have people working on Sundays, you want to take a look at the Sunday pay statute just to make certain that you don't miss something. Retail always has its own rules. And again, if you're running a retail establishment or your client is, you're going to want to take a specific look at the Rhode Island statutes on that. The other thing I was asked to talk about was the Rhode Island Pay Equity Act. A couple of things about that I think merit being discussed. One is that If you violate the act, there's actually a safe harbor provision that exists until June 30th of this year. So if you have somebody who you should be paying the same as another person, you have till June 30th of this year to make that change and ensure that that person is paid the same. Basically, it is looking at whether a person is being paid doing a substantially similar job as another worker, which is looking at skill, effort, responsibility, working conditions, irrespective of a person's job title. So simply because I call somebody a director, I can't pay them less than I would an executive director if they're both doing the same job. You can obviously have pay differences with respect to or caused by seniority, merit system, production-based. If one employee, makes more sales than another, you can pay them more. Or bona fide job-related factors like education, training, or experience. What I think is really different here versus how this law used to be is that you have to tell employees the ranges of what a salary might be when a person is applying for or seeking to transfer into a position, which is something that we never had to do before. So if I ask you, I'm applying for, a position as a paralegal at my firm, what's the salary range? You have to actually disclose that to that person. You also can't look at that person's prior salary history when determining what it is they should be paid. So while it's a little different than Massachusetts, while you can't ask the question, it really creates the same sort of situation where you have to make a determination based on what the employee might be doing for you, their experience history, within the range that you've already given them to determine what they should be paid. So I'd suggest that you take a look at that. I'd also suggest that there's a retaliation provision under that particular act. So if somebody does ask those things, you can't not hire them or fire them for that. But that's sort of the newest that exists here. With that, I really want Kate here to talk about the Voting Rights Act because I'm going to tell you I know nothing about it, and it would be a great thing for us.
So are we going to finish with me or still try to do some retaliation?
I was hoping that, you kind of dealt with retaliation.
I think we kind of talked about retaliation.
Yeah, so I think
The floor
the
is
floor is
yours.
yours.
Take it away with voting rights. Okay, so my name is Kate Bowden. I work for Disability Rights Rhode Island, and we are a federally funded nonprofit. We do civil rights work for people with disabilities if it's a disability-related legal issue. And I've been heading up their voting rights grant for 20 years. And so with our remaining time, we wanted to expose you to some of these laws that you might not really come across very often. In particular, because they give rights to people that you may know, and your folks might not know that they have these rights. So we can be ambassadors to everyone that we know when we have the information about voting rights. So in terms of the landscape in Rhode Island is pretty good for voting rights. We've been trending toward making voting more accessible over the years, especially with COVID and the scaling up of mail ballot voting and some features that were added, which I will speak to in a few minutes, in order to make that more accessible. With the Voting Rights Act, the Federal Voting Rights Act of 1965 was really designed to dismantle the Jim Crow laws and to make it possible for Black citizens to vote. That's not my area, but there is a part of the Voting Rights Act of 1965 that is relevant to what we do, and that is the right to assistance. So a voter with a disability has a right to have assistance with marking their ballot. They have a right to bring the person of their choice into the polling place, as long as that person is not an employer or someone from their labor union. So there's a procedure. You can bring the person, your person of your choice. You both sign a piece of paper saying this person is not from my employer or my union. So if a person with a disability because of being blind or not able to read or write would like to bring the person of their choice, they are allowed to do that under the Voting Rights Act. The Voting Rights Act of 1965 also prohibited things like literacy tests. So you cannot prohibit someone from voting because they cannot read or write. There's another important federal law which came out, some of you remember the 2000 election that was decided by the Supreme Court. After that election, a law was put in place called the Help America Vote Act. And the Help America Vote Act was designed to bring some floor and regularities across the board for voting. And so one right that came out of the Help America Vote Act is the right to a provisional ballot. And that is for everyone. So that basically means, if you walk into the polling place to vote and they say, sorry, you're not on the list, they're not allowed to turn you away. They're not allowed to not let you engage in the process. They have what's called the provisional ballot. You can vote that ballot. It won't go into the ballot counting machine that day because they have to have some time to resolve whatever the issue is to make sure you are eligible to vote. But once they do that, your vote will be counted. So that is an important feature from the Help America Vote Act. Another very important feature of the Help America Vote Act, which not a lot of people know about, is it requires accessible voting equipment in every polling place. Now, when the law was put into place, these voting systems did not exist. So companies had to scramble to create something that would enable people to exercise this right. But what the law says is that everyone has the right to vote privately and independently. So if I'm a person who's blind or low vision or not able to read or write, there has to be a machine in every polling place that will enable me to do that. And Rhode Island has these machines. In Rhode Island, we use something called the Express Vote, and anybody can use the machines. Under the Help America Vote Act, there is no private right of action under the Help America Vote Act. However, there is a state administrative complaint for enforcing provisions of that law.
Hey, Kate,
Yes.
can you describe for us what that machine might look like and what it might mean to somebody came in that was low vision and needed to use
Yes,
it?
absolutely. So basically, imagine going to the ATM to take money out. So it's a small machine. The voter is given a blank sheet of paper, and if they need assistance, to walk over to the machine, that the poll workers will assist them. But basically, you insert a piece of paper into this machine, and then the screen will come up. And there are headphones. So if you can't see it all, you can put on the headphones and the machine will read the ballot to you. And it tells you what the selections are. It tells you how to mark the ballot. And so if you are a person who needs to read along and hear, you can be looking at the screen. So if you have any vision, you can use the screen to mark the ballot by touching. You touch the screen for your selection, and it lights up to show that you voted. It also tells you, how that's all going to work. And then when you're done making your selections, there's a summary that you can read or listen to telling you how you voted. And then you press print and your ballot comes out and it's marked. The current system looks different from a paper ballot that other voters would be using, but the ballot is inserted into the same ballot counting machines that everyone else uses. So this is great for people who are blind, low vision, dyslexia, and also some folks who may have some trouble manipulating a pen, but can do okay with touching, or there's also a keypad attached. Does that help?
Yeah, and just so I'm clear, I do some of this work not here. I do it up in New Hampshire normally. But can you still bring somebody into the booth with you to assist you, whether it's moving around or in casting your ballot?
Yes, you would be able to bring someone with you to use the express vote, and I would expect that they would still ask you to do the same paperwork. It's called a voter assistance affidavit, where you both promise you're not bringing someone from your employer or your union. I want to kind of fast forward a little bit to, we talked about the Americans with Disabilities Act in other contexts. And I think because the Help America vote does not provide a private right of action, there's been a lot of litigation around voting rights and the ADA. So one of the important things to recognize about the ADA is that it applies to state and local governments, and it prohibits discrimination and it requires equal access to voting. So state and local governments have to ensure full and equal access to to engaging with the voting process. So that applies to all aspects of voting. So that means casting the ballot, registering to vote, in the mail ballot programs. And that is where we have seen some changes, significant changes in the last 10 years. The National Federation for the Blind has brought litigation around mail ballot voting. So prior to 2020 in Rhode Island, the mail ballot voting process was fairly limited. We limited who could use it. Now it's wide open. And the process was totally inaccessible to a blind person. So if I'm a blind person who wants to vote from home during COVID, I was going to have someone else mark the ballot for me. In my office, we approached the state. We talked to them about the ADA and mail ballot voting and the fact that there are now systems in existence to enable a person to vote remotely. Is called accessible mail ballot voting. So the state can, if I'm a person who's blind and I have technology at home that reads my screen, I can have a ballot delivered to me through a cybersecurity secure portal. I can vote from home. So it's called accessible mail ballot voting. It's now available to military and overseas voters and people with disabilities in Rhode Island. And it was put in place following my office approaching the state to become more compliant with the ADA and mail ballot voting.
So Kate, we've got just a couple of minutes left, but I want to kind of talk to you a little bit about your office, and if I've got somebody with me who has a disability and they're at a voting booth and they have a problem, do you guys help with that?
Yes, so the funding we receive came from the Help America Vote Act. So agencies like mine in every state get this funding, and they want us to make systems more accessible. They want us to work on training poll workers. They want us to educate the public. So we have a year-round hotline, and at any time, anyone can contact our office. They'll put you through to me, and I can talk to you about accessible options. A very hot topic that could have been a whole section here is mental capacity in voting, and when can you not vote? And I have worked with the state to clarify those issues on their voter registration form and online. So in Rhode Island, we are clear that you do not lose the right to vote unless your capacity to vote has been adjudicated by a court of law. So you retain the right to vote unless there's been a court order evaluating that and indicating that you're lacking capacity. So we welcome all kinds of questions, and we're available to speak further on these kinds of issues.
All right, I think that's our time, so I think we turn it back over to you, Barbara. Do I turn it back over to you, or do I say thank you to everybody, or what do I do?
Okay. Thank you, everybody, and thank you. And thank you, panel. That's great. I want to remind you that you need to exit by the back door which is to take a left out of this door and a left when you hit the end of the corridor. And I'm sure the security people will show you the actual exit door. If you want to join the protest that's going on momentarily on the front steps, you'll have to walk around the building. The front door is locked. Our next session is February 10th. We were going to delve a little bit more in detail into these and similar statutes. If you haven't registered yet for future sessions, please do that through the Rhode Island District Court website. Thank you.